Okay, so once again, welcome. My name is Lorraine Gilbert, CEO of WealthWise Financial, and we're continuing our webinar series that we do each month. Today is June 25th of 2024. And today we have with us Matthew Bourque, and I'm going to tell you a little bit about him. First of all, let me introduce a couple of people on our team as well that have joined us here. We've got John Milligan, our Director of Investment Strategies, and we've got Carissa Adams, our paraplanner. And with that, let me just introduce you to Matthew. So Matthew is the managing attorney of the Dallas and Houston offices of RMO LLP. And RMO LLP is a law firm dedicated solely to trust and estate litigation. He helps beneficiaries and fiduciaries resolve disputes related to inheritance theft, breach of trust, loss of capacity, and protection of elders. Today, he's going to speak about financial capacity planning tools, how they can help your loved ones, dangers to avoid, and legal action you can take if it's too late to plan. Matthew went to Boston University School of Law. He also graduated magna cum laude from the George Washington University. So he is very experienced in this idea of helping people out in these areas that are not always fun to talk about. So Matthew, with that, I'm going to turn it over to you to tell us more.
Thank you, Lorraine. I really appreciate the kind words and the introduction. As you mentioned, we're going to be talking today about tools that you can use to help with your financial capacity planning. As Lorraine mentioned, myself and the attorneys at my firm are probate dispute specialists. We help clients deal with the fallout when someone disturbs a vulnerable person's estate planning or their capacity planning, which is what we're going to be talking about today.
And Matthew, let's just point out that your offices also, in addition to Texas, are throughout the state of California, and we have clients in both Texas and California. So those are the two areas that you guys work in.
That's right. We're in Texas and in California. We have offices in Los Angeles, Orange County, San Diego, Pasadena, and Fresno, as well as Dallas and Houston. So we're going to be talking about financial capacity planning today, and that's planning generally for aging. And aging comes with challenges. Last month, the WealthWise webinar focused on brain training, practices designed to slow or even prevent cognitive decline. Despite our best efforts, cognitive decline is sometimes inevitable, whether that's due to dementia or stroke or even natural aging processes. Financial capacity planning can help protect your loved one as they age. So when do we need financial capacity planning? Maybe your loved one was just diagnosed with Alzheimer's disease. Something's off and you're worried. They're displaying an increased risk tolerance. Maybe there's a new friend or a neighbor next door who's giving them questionable advice, and you're concerned. Does your loved one need protection? Are their finances at risk? What can you do to help? Today, we're going to discuss various tools that can make your life easier and protect your loved one when they experience cognitive decline. We'll discuss when to recognize when financial capacity concerns arise, and we're going to touch on some legal remedies for when capacity planning isn't enough. So, what do I mean by financial capacity planning? Well, I'm talking about legal documents that can help plan for a loved one's cognitive decline and protect their assets. We're using legal tools here in a way as the same way as preventative medicine, say. Now, I practice in Texas, but As I told you, our firm has offices in California, and I'm aware of the law there, and that a lot of states are going to have the same or something very similar to all of the financial capacity tools that we're talking about today. Also, we're focusing here on financial capacity. For most of the documents that we're going to discuss, there's an analogous capacity planning document related to your loved one's health and well-being. For example, you have in Texas a financial power of attorney and a medical power of attorney. Today, we're just going to be focusing on the financial side. So, as I just mentioned, financial power of attorney. I bet lots of you have heard of this. Many of you probably have, but I'm going to explain it for the uninitiated. This is a legal document that affects two people. You have the principal is the person who grants the power of attorney and signs the power of attorney and gives power to someone else. Then you have the agent, who is the recipient of that power. You may hear the agent referred to as the attorney in fact. We don't use that terminology much anymore in Texas, but you'll hear it from time to time. It means the same thing. So the scope of a financial power of attorney can vary. It can be very limited for a specific purpose in a specific time. Think about a power of attorney you might give to your real estate agent to close on the purchase of a house. But today, what we're talking about is the general typical financial power of attorney that grants broad powers. It allows the agent to step into the shoes of the principal. And the agent can, for example, manage assets, enter transactions as the principal, withdraw the principal's money, participate in lawsuits on behalf of the principal. There are some clear benefits to these broad financial powers of attorney. They're relatively easy for your attorney to draft. They're usually convenient to use. And they're pretty far reaching. If you want somebody to take care of you financially, well, a financial power of attorney is going to do what you intend it to do for the most part. But there are many drawbacks to it. For one, this is probably the most important. You got to be really, really careful with the person you choose as the agent. You got to have complete trust in that agent. In theory, the agent could use the power of attorney that you're granting to steal your entire estate and disappear to some country without an extradition treaty. But what a lot of people don't realize is that powers of attorney can also be dangerous for the agent, for the person exercising that power on behalf of the principal. Because the agent, when they agree to become an agent, becomes the principal's fiduciary, and they have all the accompanying fiduciary duties that come along with that. And some of those duties aren't necessarily intuitive. So I'm going to give you a hypothetical here. Let's say dad executes a power of attorney naming son as agent. Then down the road, dad loses his mental capacity. Now, dad every Christmas would give an $100 check to each of his grandchildren. So dad can't really speak anymore because of his loss of capacity, but son wants to continue this tradition and is gifting under the power of attorney. That may be a breach of fiduciary duty committed by the agent, because these gifts are not in the best interest of dad, who is now incapacitated. In other words, that $100 should be spent on dad. Now, it's not every case, but that's an example of how an agent can incur liability for acting under a power of attorney. Another hypothetical, let's say son, the agent here, loans dad, the principal, a sum of money, and son's only charging dad with 1% interest. Pretty good, right? Well, technically, son is benefiting out of that transaction that son used his power of attorney to accomplish. So that could be breaching son's fiduciary duty. In addition, there's some other downsides. A bad actor can convince the principal to revoke the good power of attorney and sign this new power of attorney that's naming the bad actor as an agent. And then the good one that you have is useless. And there are some instances when the power of attorney, even if you have a good one, it won't fulfill its function like you want it to. Uh, Sometimes banks will receive a power of attorney and they'll refuse to honor it because the signature is illegible, or maybe the signature is too legible based on prior examples of the signature. Whatever the case, something triggers the bank's internal processes and the power of attorney isn't doing what you intend. So those are some advantages and disadvantages of a financial power of attorney. Next, I'm going to talk about supportive decision-making agreements. This is a new capacity planning tool. I say new, well, it was introduced first in Texas and in Delaware in 2015, but in legal standards, that counts as new. California introduced this type of document in 2022. Now most states have some sort of version of this document. So this is a document for people who need a little extra help making their decisions. You have your grantor, who's the person that's signing the supportive decision-making agreement. And then you have the helper, an advisor, you might call them. Whoever it is, it's a trusted person who's going to work together with the grantor to help the grantor with any number of things. For example, the supportive decision-making agreement could say that, hey, when I'm making financial decisions and when I'm choosing what my investments are going to be or listening to the advice of my financial advisor, I am going to be working with this other person who I'm naming as my helper. And I am saying they're allowed to participate and help me make this decision. Like a power of attorney, the grantor should choose someone that they know and trust to be the helper. It's especially important to get someone who knows the grantor very well, because we don't make decisions in a vacuum. The decisions we make are based on our entire lifetime and what we've encountered, and there are any number of things that could inform our choices. And the better a person knows you, the better a helper they're going to be, because they're going to be aware of that experience that you've had. There are some downsides to supportive decision-making agreements. Like I mentioned before, they're new. You might run into some delays when you try to use them because many institutions are going to have never received one of these before, never seen them. They'll look at the piece of paper and say, what do I do with this? Then they'll kick it up to their legal department. Legal department will sit on it for a while. So if speed is your goal here, you just want to be cognizant of that. Also, unlike the financial power of attorney, you need two people to make this document work when you're actually trying to use it. With a power of attorney, the agent can go to the bank by themselves. They don't need the principal to come with them. With the supportive decision-making agreement, you're going to need both people, the grantor and the helper, to show up together. Okay, so we're going to talk about guardianships and conservatorships a bit later, but in general, what you need to know is a guardian or a conservator is a person appointed by a court to manage the finances of an adult who has lost mental capacity. And I use two different names there. For this role in Texas, we call them the guardian of the estate. And in California, they're called conservators. And I'm going to use guardian and conservator interchangeably during the course of this presentation. So what happens when a guardian or a conservator is appointed by a court? Well, it strips the rights away from the protected person and vests those rights in the guardian or conservator. We contrast that with a power of attorney. The principle under the power of attorney is sharing power. They're saying, I can still make these decisions, but I want this other person to also be able to make these decisions if I'm not there. With a guardian, it all starts and stops with the guardian. The protected person no longer has the ability to speak for themselves by law. That's a lot of power. You might be thinking to yourself, what if I lose capacity? Who would I trust with all that power? Well, by the time you lose capacity, you may have lost the cognitive ability to advocate for yourself in court. So many states allow this device here called a declaration of guardian. And that's a written document that you can make before you lose capacity that says, if I do lose my mental capacity, here's who I want to be my guardian. In Texas, we have a specific document for this tool, and it's called a declaration of guardianship in the event of incapacity. I know it's a mouthful. In California, you do see these provisions, but they're usually built into a trust or maybe into a power of attorney. Now, it's important to remember with these documents, these declarations of guardian, that they do nothing on their own. Think of them as a letter to the judge that says, Dear Judge, I want you to appoint this person. And the judge doesn't need to follow your recommendation. And that's typically a good thing because a person that you trust today might not be the same person you trust 20 years from now. So it's generally good that there's that escape hatch there. Now, there's something else you can do with a declaration of guardian that might be even more important to you. You can name a whole list of people who you don't want to be your guardian when you lose capacity. Is there anyone in your life who you never want managing your finances? Well, just list them out on the declaration of guardian. And unlike the other function of a declaration of guardian, the people you don't want, that's going to be binding on the court. The court is required in Texas to not appoint anyone who you've listed as forbidden on your declaration of guardian. So really the biggest downside here with this financial capacity planning document is that it needs to work in conjunction with a court proceeding. You need the court to come in and actually appoint that guardian. And guardianship proceedings are costly and time consuming. There's a lot of steps to them. So it's not perfect on its own, but in most instances, it's better to have one and not need it than to need it and not have.
Matthew, I'm just going to ask you a quick question here because I have been asked this question in the past. How long does that take for the guardianship proceeding and to actually get it done? And I mean, I know just like an estimate, I know you say it's costly. What does that look like?
Yeah, so it depends on the lawyer's favorite saying. It depends. It depends on what county you're in, what state you're in first, and then what county within that state,
Mhm.
because counties have their own local rules and they have their own backlogs. Some counties, it's like an open door. You can go through pretty quickly. Other counties, you're waiting for months to get a hearing. So on the short end, I can speak to Texas. If you're just going for a normal guardianship, expect that you're going to need at least 2 months. And then depending on where you are, it could be up to 6 months.
And then
So
as far as approximate costs, I know it varies with counties, et cetera, but a ballpark?
I don't think, I mean, don't hold this as gospel, but you want a number, I'll give you a number. Absolute lowest of the low, 10,000.
Okay. So at least in that, and so that is, so something to consider that this is, you don't want to wait to get to that point of guardianship. So that's the really point of what we're talking about, how to use tools so that you don't end up in the court system and how those can be avoided. But just to clarify, is that something that your firm does? Is the guardianship proceedings too, or not?
Yes, we do
Okay,
guardianship proceedings, and we'll assess your case based on your needs and see if we would be the right fit for you. So we don't
got
take every guardianship that comes through our
sure,
doors, but we do take guardianships, especially the contested ones.
got it. Okay, thank you. That helps a lot.
Sure thing. Next, Lorene, I'm going to be talking about something that you know about very well, which is asset protection trusts. And sometimes these are called spendthrift trust. What we're talking about here generally is putting assets into a trust for the benefit of a person who needs financial capacity planning, and then imposing strict conditions for distributing those assets, for when they can be distributed, how much, is it principal or is it interest, under what conditions. And there are generally pretty strict conditions put on those distributions. These asset protection trusts are often used to shield future creditors from your assets, but that's not quite the use that we're talking about today, um, although it is very useful for that purpose. So let's say dad just got married in Vegas to someone named Ferrari that he met at the craps table. Now, dad says he's in complete control, but you've got your suspicions that Ferrari might not be a good actor. Now, if dad's cash is in a spendthrift trust, he probably wouldn't be able to withdraw large sums to give lavish gifts to Ferrari. So if you have an asset protection trust in place, when Ferrari asks dad to buy her a new Ferrari, you've got some protection. Now, there are some downsides here. Many, but not all states recognize this type of trust. And there are fewer states still that allow the same person to fund their own asset protection trust. Also, the person you put in charge, the trustee of the trust, is in a very powerful position. just like power of attorney, you want to pick someone you trust. You pick the wrong person and you have the fox in the hen house. But doesn't necessarily have to be a specific person. Institutional trustees can really help out in that regard. And Lorene, I think you have some additional words on this.
Absolutely. So, you know, so we have a corporate trustee that we utilize. So we clear securities through LPL Financial. LPL Financial owns a corporate trustee company. And this has been very valuable for our clients, where we can list the private trust company in many different capacities. One, as simple as a successor trustee. So, to what Matthew, you were talking about earlier, in appointing people to be power of attorney for financial purposes, similarly, in a trust, we can list the private trust company as a successor trustee. And there are many reasons to do that. And the reasons are for all the warning signs that you said, as far as appointing a person. A person can be problematic. A person has to have fiduciary capabilities, and that's not an easy job. And even when it comes to distributions, like you were talking about before, it can become a conflict of interest. And to avoid any of conflicts of interest, and as well to make sure that fiduciary duties are being performed accurately, that's a corporate trustee's job. This is all they do. This is what they do day in and day out. And in addition, here with the idea of any kind of irrevocable trust, the private trust company can be the trustee, so that an irrevocable trust can be set up. And whether it's for asset protection, spendthrift, for a variety of reasons, and even upcoming with the estate planning issues that are going to take place if we don't renew legislation and extend our very high exemption on estate taxes, there's going to be a lot more people that are going to be subject. So there's lots of things that can be done with these ideas of irrevocable trust. So I just want all of our clients to understand that we have a resource. And what that resource does is avoid ending up in the courts with Matthew for any kind of issues. It's a safety measure. And I can list, a couple of examples I can just think of with some of our clients. One example I'll give is that we can manage any already existing irrevocable trust that's been put into place, even if there's a different trustee listed. And a lot of people are under the misimpression that once that irrevocable trust is set up and there is a trustee that's on there, that cannot be changed. That's not true. So we have been successful at being able to change trustees that have already been listed to help by having the private trust company involved. Another example I will give is we've had clients who have had substance abuse issues. And those are very serious. And even when families think that those issues are not resurfacing, my experience has shown, and I can think of a particular client where this happened, where someone fell back into those issues of substance abuse. And by listing a corporate trustee, this helps the person. It is not to limit the person's ability to access money. It actually protects the person so that, like we're talking about here, Spendthrift Trust, so that it lasts a lifetime and that the money doesn't just disappear. So there's just a couple of examples, Matthew, of using the private trust company. And I'm happy to talk to any of you some more about how we can help in that regard.
Thank you, Lorene. So yeah, it's trustees serve a very important role. In addition, there are some private, professional, independent trustees that may also be available depending on your circumstances. One important downside to spendthrift trusts, powers of attorney, anything we've talked about so far, anything that requires the protected person put pen to paper and sign their name. And that is, what if it's too late? What if dad can't understand what an asset protection is, or how it works, or what it does? Well, it's entirely possible that dad has lost his capacity to execute the trust agreement, and any trust that would be created would be invalid. So that's going to lead us to our next topic here. When can we recognize when a loved one loses capacity or is losing capacity? You might already be concerned about their health. When should we be concerned about their finances? So, in general, when a person is signing a capacity planning document, they have to understand what they're signing, how it works, and why they're signing it. In Texas, this is called contractual capacity, and the legal standard, if you want to validly execute a document, is that you have to appreciate the effect of what you're doing and understand the nature and consequences of your acts and the business you're transacting. Texas law also recognizes that we all, by default, have the capacity to enter into these contracts until proven otherwise at court. So we do enjoy this presumption that we have capacity, but if there's medical evidence or even non-medical evidence that someone's incapable of understanding what they're doing, then you can meet that burden and invalidate the document. It's also important to know that capacity can vary from person to person. When you're trying to see, well, hey, my mom's a rocket scientist. She was just diagnosed in the very, very early stages of dementia. Well, maybe she does have capacity still to understand what an asset protection trust is and to be able to access, to be able to understand it and to execute. At the same time, we don't want our circumstances to cloud our judgment when we're assessing our loved one's capacity. It's difficult to believe that our loved one is declining. We don't want to believe it, so we don't see the decline. So in these circumstances, it could be helpful to get the perspective of someone else, any outside party, but specifically a neuropsychologist or a neurologist. Neurocognitive testing is going to be really the best indicator here of whether someone has capacity to be making financial decisions for themselves. I've told you about some hypothetical scenarios already. I'm going to talk about a few more here. And we're going to be talking about the potential harm that could be caused when someone loses capacity, and maybe they have financial capacity documents already, but they've been ineffective for whatever reason. Maybe they haven't executed financial capacity documents. Maybe there's a bad actor who procured financial capacity documents. For whatever reason, the financial capacity planning that you intended isn't working. So, what potential harm are we trying to avoid here? Well, we're looking at maybe lavish gifts by the protected person for folks who aren't friends or family. We're talking about, let's say you walk into mom's condo And on the kitchen counter, there's a power of attorney naming your long lost cousin as mom's agent. And mom doesn't have a good explanation for it. In fact, she doesn't even know what the document is. Talking about when you see unfamiliar names show up on your loved one's account statements as co-owner or signer, or payable on death beneficiary. There could be someone taking advantage of your loved one, and there's going to be a need for more assertive action there. Also, your loved one may need protection from themselves rather than a bad act. They're making poor decisions and they're wasting their own estate little by little. Now, often these two categories intersect. Maybe the pool boy sees grandma glued to HSN and grandma's buying everything she sees. And the pool boy thinks to himself, well, here's an opportunity. So it's you got to watch out for all this. And that's going to lead us to legal remedies. What can you do to protect your loved one when capacity planning isn't enough? Maybe your aunt's Alzheimer's has progressed to a point where she can't even understand she's being taken advantage of. And despite your best efforts, the bad actor has still infiltrated your loved one's life. And like I mentioned before, what happens if the bad actors themselves are the ones that are doing the financial capacity planning for your loved one, planning to use those documents to exploit your loved one? Well, that's where we come in. Probate litigation attorneys. So the most powerful tool that you can use to put a stop to wasteful or harmful spending or financial decisions is the guardianship or conservatorship. And like we mentioned before, it's going to protect your loved one by taking their rights away to make financial decisions. This is an extreme remedy. It's one of the most extreme remedies there is. So most states make it very difficult to achieve guardianship or conservatorship. In Texas and in most states, we're presumed to have capacity until proven otherwise. So the specifics are going to vary from state to state, but in general, all states make it difficult. In Texas, you've got to prove essentially that the vulnerable person has lost capacity permanently or for the foreseeable future. The legal standard there is because of a physical or mental condition, the person is substantially unable to manage their own financial affairs. So someone who has good days and bad days, maybe some days they can manage their affairs and some days they can't. Typically, a guardianship is not going to be appropriate there. Similarly, someone who has the cognitive ability to take care of themselves and to make good decisions, but they just don't use it. They just have poor judgment and it has nothing to do with their cognitive ability. It's just what they're choosing to do. Guardianship's probably not going to be appropriate there. Also, to obtain a guardianship in Texas, you're going to need a doctor's report, a very specific one. It's called a CME, and you need that CME to show that there's actually incapacity. Also, in most states like Texas and California, you need to prove that the guardianship or conservatorship is truly the last resort here. Remember, we're taking away someone's rights. So you have to prove that the other ways that you could protect their interest, like the tools we discussed earlier, are going to be insufficient. There are lots of downsides. Like we mentioned before, it can be lengthy and expensive. So a normal guardianship is typically going to be inappropriate for emergency situations. That said, if you do think legal intervention is going to be necessary and that you need to file a guardianship, you can do a few things quickly that cost very little and can be fairly effective. And the first is disclosure. You can let everyone who might have an influence or power over your loved one's finances know that, hey, we're going to start a guardianship proceeding, or hey, this person here, they're up to no good. They've been stealing mom or dad's money. And you may not want to necessarily use the word stealing, but you want to convey that there's potential danger here to your loved one's accounts. And oftentimes that will just result in a freeze, and it will achieve what you want to achieve. It'll protect and preserve those assets until a guardian can be appointed. There's also a legal device called a notice of lis pendens, or just lis pendens, that is especially useful for a quick and easy way to prevent the sale of real property. It's a document that you file in the real property records that says, hey, there's a legal proceeding. Ownership of this property and the rights regarding this property may be disputed. So if you're going to be buying this property, this is putting the whole world on notice by filing in public deed records. If you're going to be buying this property, watch out, there could be problems. So almost always this is effective in preventing the sale of your loved one's residence, minerals, or other real property, because the buyer's title company isn't going to issue title insurance for something with a lis pendens on it. Now, if we're talking about an under the table transaction, then you might need more. And this is also something you definitely want a lawyer to do for you, along with all these other documents we're talking, but especially the lis pendens, because some states have really steep penalties if you file an improper lis pendens. So keep an eye out for that. Now, are you out of luck if you need to act quicker? No, you do have options still. You may have heard me mention a normal guardianship earlier. Well, what's not a normal guardianship? Talking about a temporary guardianship or a temporary conservatorship. And just what I wish they would do is replace the word temporary with emergency, because that's what it is. And it's an emergency guardianship because something bad is happening right now, or it's about to happen right now if we don't take action. For these types of guardianships, you generally need to show that there's an emergency that is threatening or causing harm right now, and you need some proof that your loved one lacks capacity. The nature of that proof is going to vary from state to state. There are downsides to these proceedings, like the official name. They're temporary. They usually don't last that long. Think 60 days, 90 days. But really, maybe the biggest disadvantage is the expense. They're just expensive to achieve because you're telling your lawyer, we need this right now. They have to stop everything they're doing, and they're putting all hands on deck to get this application for temporary guardianship or temporary conservatorship filed. So they're very expensive. And then you're going to need to follow that up typically with a permanent guardianship. So in some ways, it's almost like you're doubling your costs. Also, you have emergency injunctive relief as a legal remedy. Here we're talking about temporary restraining order, temporary injunction, something where the court steps in and says, hey, bad actor, stop doing that. I'm going to order you to stop doing what you're doing. And occasionally they can say, oh, and also you need to return that money. You need to do this. You need to move out of that house. So injunctive relief is a little bit different than temporary guardianship in the ways that it affects the different people. A temporary guardianship is going to appoint someone and say, the court's going to say, this is the only person who has the power to do these things. This is the only person who can move money around in dad's accounts. So if anyone else tries to do it, they can't. Injunctive relief will be targeted directly at the wrongdoer, and it'll say, dear world, this wrongdoer can no longer access these accounts. This injunctive relief is typically only as effective also as it's disclosed. So your dad's bank isn't going to know about it until you provide them with a copy of the temporary restraining order that says, stop letting this co-sign or co-sign. So like temporary guardianships, emergency injunctive relief is also very expensive, but sometimes it's really the only option that you have available to stop the harm from occurring. There's another legal remedy for the exploitation of a loved one that I wanted to mention. That's mental health commitment, a legal procedure to stop a vulnerable person from harming themselves by placing them into a mental health institution, usually against their will. These are usually used in a physical health context, but in a pinch, if you can meet the requisites, they can be useful to prevent financial harm as well. After all, grandma can't liquidate her savings to buy Bitcoin if she's been committed for a few days. And this is another area where state laws are going to vary wildly, but generally you need to prove that the person is at risk of harming themselves or others. And really, we're talking about physical harm here. So if there's no physical harm, it probably won't be appropriate to stop the financial harm. It's a powerful tool, though, if you can use it, but it's very temporary.
Yeah, Matthew,
It's
I thought that the states had pretty much almost eliminated it. So what does that look like for this mental health commitment? How long does that go into effect?
well, in Texas, what you get is a 72-hour, and those are handed out like candy. Once you prove that the person is actually in danger or is causing danger to other people, a 72-hour hold is pretty much automatic. And if you prove a continuing danger, it's harder, but you can extend that for up to a week. But then extending it any longer than that can be very, very difficult, at least in Texas, in my experience. If these remedies sound extreme, it's because they are. But like I mentioned, sometimes they're necessary. Uh, let's say dad has moderately advanced dementia. You find out dad's caregiver persuaded your dad to execute a financial power of attorney that named the caregiver as agent. This is going to raise some huge red flags. Caregiver just got released from prison for financial fraud. So you take dad aside, you explain the potential exploitation, and he agrees. He even signs a revocation that cancels the power of attorney. Well, this doesn't prevent the caregiver from returning with another power of attorney the next day for dad to sign that revokes the good one. Now you're back to the bad one again. It's situations like this where the extreme legal action can be necessary. So, finding,
Matthew, yeah, go ahead.
no, please.
So in our world, what we see quite a bit is someone, clients have IRAs, right? And only the person who owns the IRA can we talk to make any kind of distributions or whatnot. And if there is not a power of attorney in place and somebody becomes incapacitated, we've got a problem.
You do.
Can you just address that?
If the person has lost the capacity to be able to understand what a power of attorney does, to be able to understand that, they may understand that they love their daughter and they trust their daughter, but if they don't understand that the power of attorney is letting daughter do all these things, all of these transactions, have all this control, then they don't have capacity to execute it. And if they did, it would be invalid under the law.
And so in that case, the remedy would be a guardianship.
It would be a guardianship. I mean, if you do have to prove harm if you're seeking a temporary guardianship for immediate action. But if you're seeking a traditional guardianship, yeah, that's probably your remedy there.
Yeah. And that is why I just wanted to address this. One thing that I've put into practice for our clients is when I see someone is potentially heading in that direction, then we advise that we get that in place immediately so that, for instance, the other spouse would be able to take care of that spouse's, or if they're both heading that way, then we talk about another family member. So that's something that we've been proactive, because I've seen it come to that place where then it's in effect too late, in a sense. I mean, you need legal action.
It's very important to be proactive. Exactly, Lorraine. I couldn't have said it better myself. That makes me think of kind of a related issue, though. Now, let's say you're in the same position, someone's lost capacity, and you need to make decisions about their IRA. Now, in through the door walks this person you've never seen before. You don't know their relation to the incapacitated person, but they say, here's a power of attorney, says I get to make the decisions. You better do what I say, otherwise you're disregarding my authority, and you are breaching your obligations to your own client if you don't follow my wishes. What do? Well, thankfully, under Texas law, at least, there are some kind of safe harbor provisions where you can refuse to honor a power of attorney if you believe it's being used for improper purposes, or if there's another reason you believe it's invalid. So you do have some protection there. Again, this is something that varies state by state.
Yeah, another thing for our audience to think about, because I have this happen as well, is that, oftentimes the parent will say, I'm going to have my child take this on. And that's fine. But when you are looking at your kids, typically, if you have more than one, there's probably one that is better at finances than another. And please choose the one that is better with the finances than the one that's not. And you can have backups, you can have multiple, but what I've seen happen that sometimes I could classify as not the best choice is a parent might pick the person who lives the closest for financial, instead of the child that is actually the better person at finances. So from our perspective, we would rather see the child who's better with finances, no matter where they are, because it doesn't matter to us where that person resides when it comes to financial matters. Now, when it comes to healthcare matters, you may want the person who's closest physically, but not for financial matters. So that would be some input that I would give.
Yeah, great advice there, Lorene. And I was going to mention the same thing about the medical power of attorney before you mentioned it. If someone's going to be upset that they're not the financial power of attorney, well, they may be a more appropriate medical agent under medical power of attorney, and sometimes that can bring peace to the whole family.
Exactly. Exactly. I agree. Well, we just have a few more minutes left. This has been fantastic, Matthew, just amazing. And Carissa, let's have people raise their hands. If anybody has a question, we will have Carissa unmute you. You just raise your virtual hand on the Zoom, and then we can quickly answer any questions. And of course, as always, you guys can email me, and I can also put you in touch with Matthew as well. And I think, Matthew, you have a slide that has your contact information. Let's put that up at the same time. And then, Carissa, are there any questions here?
No questions so far.
Okay, well, we have taken the whole hour here, really. And Matthew, once again, thank you so much. And like I said, please, anybody on this call, please contact either myself or Matthew, and we can help you with additional information. So thank you, everybody, for participating. Thank you, Matthew, for this great presentation. And we'll see everybody next time. Thanks so much.
Thank you, Lorraine. It's been a pleasure.
Mm-hmm.